The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Good morning. We have three cases that will be submitted. They are State of Iowa versus John Arthur Wilson. Second case is U.S. Bank National Association versus Kathy Cullen and others. And the final case is Gary Coble versus Wells Fargo Bank and others. That last case is now submitted to the court without argument, and we will hear the arguments in State versus Wilson. Mr. Dial.
Good morning. May it please the court and counsel. My name is Nicholas Dial, and I represent John Arthur Wilson. John Wilson had an appeal pending at this courthouse, and in that appeal, an alleged forgery was filed. John was suspected of doing this. 55 days after that document was filed, Des Moines police, using a K-9 unit, sniffed John out hiding in a sump pump hole with a rubber tub over his head. That evidence, and evidence of his initial flight and escape from police, was submitted to the jury as evidence of flight. That's not constitutional. The issue is whether that evidence of flight was properly before the jury. Now, the state will cite to Wigmore, McCormick for the proposition that evidence of flight is evidence of a guilty mind, guilty conscience, and thus of guilt itself. You can go all the way back to Blackstone for that proposition. But the question is, a guilty mind of what? What Blackstone had in mind was stop thief and the accused runs. There needs to be a connection between the crime that is being alleged and the flight in order to show that the guilty conscience is indeed of the crime that he is charged.
Can the jury draw that connection?
Your Honor, I believe that this should be completely in the hands of the judge at the outset, because without that connection, it's just character evidence. It's just another bad act. And that question is one for the judge, whether or not there's that connection. Because if we're going to say that it's a guilty conscience of the crime charged, then the state needs to draw that connection, show that nexus, that the evidence that they're introducing is indeed for the case that we're in front of the jury for. Once that connection is drawn, then it would be up to the jury as to give that evidence weight along with all the other evidence as to guilt. If there's not a connection in time, place, or other circumstance, then all we have is another bad act. It's wrong to run from the police. And if you can't draw a connection between that flight and the crime that they're being charged with, then it's just another bad act, character evidence, and it's not properly before the jury.
Well, why can't you, on the record, draw the connection? I mean, admittedly, it's 55 days, and that's more remote than a lot of the case law might suggest. But isn't there enough in there that a jury could say, well, you know, why was he running? It must have been because of the charge.
I believe that when a jury is looking at this evidence, why did he run? He must be guilty. That's an assumption, that's conjecture, suspicion that he must be guilty of what they've charged him with. But when the connection is not there, as in this case, 55 days have passed, why was he hiding? He must be guilty. That is not a connection. That's not a connection to show evidence of flight. And the state should show at the outset to the judge why that evidence should come in, because we don't want a jury making assumptions or unfair inferences from the evidence to infer guilt when there's not a connection in the first place.
Isn't part of the potential relevance of this evidence that it kind of goes to the defendant's motive to forge this document purporting to withdraw, resistance to emotional withdrawal? He was out on bond pending appeal, and the state's theory is that he forged the document and sort of delay things and be able to continue to stay out and have his freedom. And the flight is also shows that he wanted to continue to have his freedom. So isn't it part of the kind of central motive in this case?
That would be a more convincing argument if the initial contact from the police had been a marked police car with a uniformed officer initiating the first contact, and that's not what happened. An individual in an unmarked car got out of their vehicle, or undoubtedly armed, and that is when Mr. Wilson first took off. Now,
But wouldn't he conclude she was an officer? She's wearing her badge and her firearm is visible?
the record isn't clear as to what John knew at that moment when that person came out. And even at that point, we've got 15 days from the filing of that document to this new evidence of flight.
So instead of 55 is when he's hiding in the basement. 15 days or 2 weeks after he files the document, there is when he ran from the police.
Yes, Judge.
2 weeks later.
Yes, a little over 2 weeks later is when the officer, not in uniform, approached him at first, and then he fled through a residential neighborhood and escaped, and then they found him later. In that
Just so
investigation,
we're clear, the record also shows that a marked police car also engaged in that first pursuit, and he escaped from a marked police car that time.
yes, Judge, he did, and he was charged with eluding in a separate case number. And
That charge wasn't brought up, was it, during the course of the trial? The actual eluding offense wasn't brought up during the course of this trial, was it?
The fact that he was charged was not brought up, but every fact that would be necessary for guilt in that charge was brought up. It's just another bad act at that point if you can't draw the connection to the forgery. It's not connected in place. Obviously, the scene of the crime was this courthouse. It's not connected in time, certainly not the 55 days, and 15 days is quite a long time for a lot to happen as well. And there's no other circumstance that ties the evidence of flight to the forgery. They didn't find any evidence of forgery in the car. They didn't find any evidence of forgery in the house. No admissions were made. There's no other evidence of forgery collected. That's different from some of these other cases where the flight may not be connected in time. Weeks may have gone by, LeMaster's, for example, but there are other circumstances. LeMaster's was a murder case. The accused was in the victim's car. There was evidence essential to finding further evidence of the murder in the car. That's an example of a circumstance, but it's not connected in place and not really in time to the alleged crime where evidence of flight would be admissible.
Well, Counsel, you've been focusing, it seems to me, on sort of one prong of the other act's analysis, the connection, the relevance to an issue other than character. Why don't you address for us, if you would, the relationship between the prejudice resulting from the admission of this evidence as compared to the probative force of the evidence?
Yes, Judge. The forgery itself was a court document filed here. The probative value of him running from the police when there's no other evidence that was collected when he ran or when he was found in the home, this is a sensational story. It's a car chase, hiding with a rubber tub over his head. That's a really good story. But it doesn't lend anything to whether or not John Wilson signed the document that was filed here. The prejudicial value is extraordinarily high. It's an exciting story to present to the jury.
It's exciting or interesting, but is it really this prejudicial? I mean, usually when you think of other bad acts, you're thinking of something that's maybe, I don't know, more something of
Drug
greater moral.
drug
Yes.
possession. drug
Yes.
cases, for example.
More than just kind of running away from law enforcement. I mean, you really think the jury is going to convict him without sufficient evidence of forgery because of this incident where he was hiding in the basement or whatever?
If the question that the jury is asking is, why else would he be hiding? He must be guilty, then that definitely could be the case, that a jury would find him guilty based on his acts in the hiding and the escaping and the chase through a residential neighborhood, as opposed to what would otherwise be proving beyond a reasonable doubt that he had signed a document and filed it with this court.
Would you agree with me that the state did not make a big deal of this at trial?
Your Honor, I wouldn't agree with that. Officer Moody was called for the sole purpose of telling the story of how he was discovered. That's not even relevant. They know that he was discovered. He sits at counsel table with his attorney. They know that they found him. Finding him doesn't lend anything to the forgery itself. Officer Moody was called so that the color photographs of the sump pump hole could come in as evidence. That doesn't lend anything to whether or not he signed a document. It's very prejudicial, but it does not lend anything to the forgery. That was the only reason Officer Moody was called.
Was there any instruction given in this case on flight? I mean, did the state request any type of flight instruction?
No, the state didn't request a flight instruction. In reviewing the cases...
So it wasn't part of any of the instructions in this case?
No, it's not part of the instructions. That wasn't requested. The cases that we have that refer to evidence of flight are discussing jury instructions, precisely because in each of those cases there is a connection in time, place, or other circumstance where we have already determined that it is indeed evidence of flight, and then the question for the instructions becomes, do we draw attention of the jury to that evidence further, or do we leave it to counsel at argument?
Well, and likewise, or most often then, the state's going to request that if they have somewhat of a weaker case, that's further circumstantial evidence of guilt, and it makes their case a little easier. So would you agree with me that the state must not have thought it was all that important or significant if they didn't request a flight instruction?
If the state didn't think that the evidence of flight and hiding was necessary, they wouldn't have called Officer Moody just to tell that story. And on that basis, with the nature of this particular flight and this particular discovery and all the evidence that they would introduce as evidence of flight, I don't think there's any more attention that could be drawn by a jury instruction.
Didn't the state not, in the motion in limine, they said they didn't want an instruction because we've said you can't give it. I mean, is that why there's no instruction? Or did they not even try to request it?
The objection of counsel Branstad was to the evidence coming in altogether.
But Allen said in the motion in limine, we have said in the Bone case says we're not supposed to give, district courts aren't supposed to give the flight instruction anymore.
That's correct, Judge, and I think that he wasn't going to contest that any further and wasn't going to ask for that flight instruction. I would say...
Why did we decide in Bone that we weren't supposed to give the flight instruction anymore?
Bone was a burglary where there was an initial flight from police the night of 2 burglaries. The initial reason for stopping in that case was actually a traffic citation, and there was evidence of the burglaries found in the car, and the flight in that case was necessary to explain how they got into the car in the first place, along with the flight of the defendant from the car after he'd gone off the road. And so in that case, it was necessary for context. It was connected in time, place, and other circumstance, but it was not necessary to draw the jury's attention to it, and that would have been prejudicial. And that was my understanding of the decision of this court for that particular evidence of flight, that drawing further attention to it isn't necessary, and it should be left to the arguments of counsel. But that deals with the instruction, not as in this case, whether or not it's evidence of flight at all.
Was the other evidence so strong that any error in talking about flight and hiding from police was harmless?
In Bone,
No.
it would not have been so strong as to overweigh the prejudicial value of the evidence of flight. Not in this case. I'm at 30 seconds. I'll reserve what I have left for rebuttal.
Thank you, Counsel. Ms. Huser?
May it please the court, counsel. My name is Kelli Huser. I represent the state of Iowa in this case. First, I would like to reframe the issue a little bit. This is not a constitutional case. That statement was made. This is an evidentiary case. We're in the realm of abuse of discretion, the broad discretion of the district court to bring in this evidence as relevant and not unfairly prejudicial. The district court did not act unreasonably here when it found...
Under 404B, the district court has to do a few things. They first have to, the state has to have a non-character reason for the evidence, and I think they did in this case in the motion to eliminate, but then the district court has to weigh whether or not it is for a find whether it is for a non-purpose, and then they have to do a 403 analysis. The prejudice outweighs, the probative value outweighs prejudice. Did the district court do any of that in this case?
The district court did not. My explanation for you would be we did not challenge error preservation in this case, but if you look back to the motion in limine, the 404B issue revolved around should the eluding charge came in. It wasn't clear that that was attacking the evidence that we're talking about here today. So it was not clear to
But the, in the oral motion limine, Ms. Brand said was attacking both, if I recall.
I'm sorry, could you?
At the oral hearing on the motion to eliminate before trial, she was complaining about both, I think.
Okay. Then...
Really, my question becomes, if the district court doesn't do the weighing, do we send it back and require them to do the weighing, or do we do the weighing ourselves?
I believe this court would look at it as doing the weighing themselves, and what you can see from here is that this was not unfairly prejudicial in this case. When we talk about prejudice, all evidence is prejudicial. That's why it comes in. This was not unfairly prejudicial for some of the reasons that were mentioned, including that it was two officers that were called. They presented this evidence in a chronological order. It was, we showed up to arrest the defendant on each of these two occasions, and here's what happened. When that was presented to the jury, it was not sensationalized. It was merely the chronological order of events for this evidence to come in.
Well, maybe, but let me just ask a few questions. First, on the relevance side, I mean, I looked at a number of cases. The classic flight case, of course, is contemporaneous with the crime, or somewhat contemporaneous with the crime. And here, I think you'd agree that the flight is at least somewhat attenuated by the calendar. I mean, the probative value of the flight decreases as time increases. And then you have, on the other hand, frankly, kind of an odd situation. Strikes me as odd, at least. I mean, hiding in a sump pump with the blue plastic thing on the top of it just strikes me as at least somewhat bizarre. That's my take on it. So on the one hand, the value is kind of attenuated because of 55 days, and on the other hand, you have this kind of odd piece of evidence coming in that makes the defendant at least not very attractive. Under 403, shouldn't this just gone out? I mean, the probative value wasn't all that much. The real probative value came out of the other evidence that you had. If you do the balancing, do we really get to the results you want?
Yes, we do. To focus on the timing first, I would disagree that the timing was attenuated. This court's case law in the past has found in Winbush 13 days was not too long, and in Schaefer it was nearly a month between the commission of the crime and the
Yeah,
flight.
and I guess
So-
I'm not saying as a matter of law it's too long, but the probative value tends to decrease as distance from the crime increases, I think. You can challenge it if you want, but
I would challenge that. When the state presents an unbroken chain of evidence or chain of events, as they did here, there was the forgery. The forgery was discovered. Subsequently, after the police showed up at his door, he fled and then evaded the police for a series of time until he was found on September 20th. That unbroken chain was presented to the district court as here is the tie between the commission of the crime and the flight, and the defendant had the opportunity to challenge that timeline, to try to break those links, as is in other cases with the real reason I was fleeing was this, and that would break the chain. The record does not do that here. So the state presented.
Where's the
Well, but I'm
nexus
not sure.
where's the nexus between the crime of forgery, that he even knew he was being charged with forgery, or even knew he was being investigated for forgery at the time he ran? I mean, it could come in for other reasons, but you have to have some nexus between the crime charged and the crime that the trial is and the running. And the second part of the question is that, when they found him in this basement, was he hiding because of the eluding, or was he hiding because of the forgery? I mean, what crime does that have a nexus to? So all these cases require that nexus. And where in the record is there any showing that he knew that they were coming to investigate the forgery crime? Now, Justice Mansfield may be right that, he's trying to prolong being out, but that doesn't go to guilt of the forgery crime.
To your first question, the record shows that this defendant was paying close attention to his appellate case. And he would have been aware of all of the documents that were being filed, including defense attorney's document informing this court that there had been a forgery.
It was filed on the 10th, and they went and served the search warrant on the 11th. And even if the clerk mailed it on the 10th to him, which I don't think there was in the record, he wouldn't have got it the 11th before they served the search warrant.
Well, we can still infer his knowledge, Your Honor, because defense counsel at his trial brought up that the defendant was paying attention to the online docketing, and this would have been docketed online such that he would have known this was happening. I'm trying to remember your second question, Your Honor, if you could remind me.
The hiding in the hole, I mean, was he running because of the eluding charge, because he knew he eluded, or was he running toward the forgery charge? How do you make that nexus? Or how does the court separate that nexus?
Well, when the state presents this unbroken chain, the defendant then has the opportunity to say, I wasn't fleeing because of this, I was fleeing because of that, and then it becomes a jury question. And
He has a right against self-incrimination. He doesn't have to take the stand and do that stuff. It's your burden to show a non-character reason, and he doesn't have to refute that by his testimony.
And we did show a non-character reason here by showing consciousness of guilt. Once we've shown that connection, it's true he does not have to take the stand, but that ends up being a decision he needs to make. And that's not the only way he can show some other reason for his actions. His defense counsel at trial raised some questions about, was this the size of a sump pump? So there were other ways for him to bring in some other reason for why he was fleeing. He chose not to do that here. Once the state provides that connection to the district court, it can then go to the jury for them to weigh the credibility of that.
What is the probative value of testimony of finding somebody in the sump pump or fleeing overall? What's the probative value of that?
On the forgery charge, right?
On the forgery and falsification of a public document.
So evidence of flight indicates consciousness of guilt, which this court has recognized for 120 years approximately as being relevant and probative here. It tends to show that the person committed that crime. Now, what we're talking about is the distance in time, and when we provide this series of events together without any other reason for this particular flight, it shows that consciousness of guilt. It shows state of mind surrounding the conduct of the crime that occurred beforehand.
But again, without having any type of balancing, I would assume you would agree with me that the longer this goes on, the time it goes on, I would assume the probative value of that goes down and perhaps the prejudicial value goes up. Wouldn't that, on a scale like that, wouldn't that make sense?
Well, I think it depends on a number of factors, including the type of crime. Is there a difference between I commit a murder and you don't discover me for a year? Murder's pretty significant crime. Is that different from a theft and 6 months? That's exactly the sort of weighing that we give to the district court to decide.
I agree with you. The crimes are, that's a nice point. I mean, it depends to some extent on what the crime being charged is. Again, back to the classic case of some burglary or theft that occurred in the department store, and somebody runs when approached by the police. Among other things, he's contemporaneously at the location. I mean, there's some real problems with his presence there, and he's taken off and hoping to get away. Here we have a forgery charge, and the germaneness of flight to forgery strikes me as less than my classic case of the department store robbery, where somebody, you know, kind of just takes off and the police look askance at him, because the flight. The flight itself doesn't have, frankly, as tight a relationship to the underlying crime when it's filing a piece of paper in the courthouse 55 days ago.
Well, I would say, so my answer to that would be, Your Honor, that it still matters not only, yes, a lot of the cases it tends to be they flee directly from the scene of the crime, but we also have cases in this court's precedent where when they commit the crime, they don't know that they're going to be caught. It's when the police officers show up at their door that they realize they are suspected of this crime, and that is when they run. And that was what happened here. He committed the crime, wouldn't have known that he was caught until his defense counsel contacted this court and alerted it that the forgery occurred, and then the police showed up the next day. So it connects back to the forgery itself.
Other states allow a jury instruction, and they don't think it's too prejudicial. In Bone, we said a jury instruction is too prejudicial because it draws attention to flight, which is sort of a tenuous conscience of guilt. I mean, we recognize back in Bone it's not really great evidence of it, and we didn't want to draw attention to it. Why shouldn't we have a jury instruction on something if it's going to be in evidence to help the jury reach the issue? Because if you look at the jury instructions in the other jurisdictions, they really show what inferences has to be drawn and what the jury has to do.
I think, well, the case law in this state, including in Bone, is showing this court's concern that even when these instructions have something that says there may be innocent reasons of flight, it's still drawing the court's attention to the flight evidence instead of all of the rest of the evidence. Instead, what we have are the circumstantial evidence instructions, which just say all of the evidence coming in is circumstantial. We trust the jury to weigh that as they will with as much weight or as little weight as possible. So if a jury instruction is included, regardless of what it says, because even in Bone it had some language, I believe, of there may be innocent reasons of flight, it's still drawing the jury's attention to this evidence over the other evidence.
And with respect to the prejudice analysis, the reason we don't want to draw attention to it is because it is so exquisitely sensitive. The jury is likely to be to give it extraordinary weight and get distracted from whether or not the evidence is there on the underlying crime, right? Isn't that the reasoning in Bone?
Well, yes, with a caveat. The problem in Bone as well was showing the nexus, and this court did say if there's not much of a nexus, then there is marginal probative value, but when the state shows the nexus between the evidence, then it's not, we're not saying this evidence has very little weight, don't consider it hardly at all. We're saying it can be considered how the jury wants to consider it.
What weight should we give the affidavit of the jurors, saying that they wouldn't have found him guilty but for this evidence?
Frankly, none, Your Honor. And I draw the court's attention to appellate rule, or to Rule Evidence 606, the juror affidavits are not admissible in this court. We do not inquire into the minds of our jurors as to why they come to a particular conclusion on a verdict. So the affidavits should not have come in at all and should not be considered by this court.
Is the state arguing harmless error?
Candidly, we did not raise harmless error in our brief. However, this court, if it goes that direction, should consider harmless error in this case. We had other evidence here, including, most strongly, we had the defense attorney come in and say, I did not sign this document, as well as identify a number of issues with the document that showed that it was forged. Thank you.
Thank you as well, counsel. Rebuttal argument?
Yes, thank you, Your Honor.
Before you start, can you explain how this is a constitutional question?
Your Honor, my client has the right to be tried for the crime that he is charged with, and not for any other bad act that he has done.
What constitutional provision are you relying on, and what constitution?
Well, Your Honor, his right to due process. It is evidentiary. That's the underlying reason for these evidentiary rules. I would say it is evidentiary in the sense that this is a question about evidence that needs to be addressed by a judge.
All right, the affidavits are out, you agree?
Your Honor, that is what the rule says in my final brief.
I think we're going to follow the rule, right?
Yes, Judge. But what I am going to say in this case, there is no non-character trait. The state has said that the non-character trait is guilty conscience.
Didn't the state also say it was a motive for the crime? It supports the motive that he wanted to remain free as long as possible? Because otherwise it's kind of a bizarre crime. I mean, why do you forge a document and file it with the clerk's office downstairs unless you're trying to just delay the appeal?
It is a bizarre crime, and an interesting theory from the state regarding the motive, but they can present that evidence without telling this sensational story that has no connection in time, place, or other circumstance to that forgery. A lot of time has passed. The state's argument is it just...
The evidence is a juror could conclude, based on what I heard from Ms. Huser and what seems to be in the record, that right after he could have had notice that the state was onto his forgery, some officers showed up at his house and he ran. That's pretty close, right?
At the point that we've got 15 days from the alleged forgery being filed and his flight from police, there's no connection there. There are cases where knowledge of investigation can form that connection in time and place, well, and circumstance, but not in this case. In this case...
But if he's looking at the online filings, aren't we now within a day or two of the defense lawyer's filing? I didn't, this isn't my signature, and the police showing up, isn't that very close in time?
If the state could have shown that when they initially presented this evidence, perhaps knowledge of investigation, but that didn't happen in this record. The only argument that the state's making is this entire story is for context. The logical conclusion of that is, well, let's round up all the usual suspects, see who runs, and then we can put that running at the end of their unbroken chain of events. I don't think you can have an unbroken chain of events with 55 days in between. If the state's argument that you can, then any flight for any reason could be used for any crime, and that is a violation of my client's rights to a fair trial.
Yeah, one other question I guess I have is, let's say there was an abuse of discretion by this trial court in letting this information in. You still have the burden of showing that there was prejudice in this case, and I want you to define for me what you say what's your definition of prejudice and how it fits into the facts of this case?
In this case, there's unfair prejudice. We are introducing evidence of a sensational story of hiding from police and fleeing from police, and that does not have a lot of bearing on whether or not he signed a piece of paper and filed it with this court. The balance between probative value of the crime charged and the prejudicial value is extraordinarily high.
Well, is it because it's sensational? What's, if it doesn't bear upon a guilty mind to the crime of forgery, what is it? Is it just a interesting story to tell, or what else does it impact?
I'm not sure I understand your question, Judge.
How is it prejudicial?
It invites the jury to look at another bad act that he has done and find him guilty based on that, as opposed to the weight of, or as opposed to the evidence presented with regards to the document that was filed at this court. And that is the problem. It's not a harmless error.
So the jury would convict him because he committed the bad act of running from the police and hiding from the police and whatever?
That's why we exclude character evidence. That's why the burden is on the state to argue something more when they're introducing character evidence. There needs to be some other connection. And when it comes to evidence of flight, there needs to be a connection in time, place, or other circumstance. Otherwise, we don't have a clear answer to the question, guilty mind of what? Is this even evidence of the flight for the crime that he's being charged with, or is it something else? Is he just paranoid?
I have just one further question, if I may, Chief. And going back to the Chief's inquiry, you refer to the sensational character, and I take it you're referring to the sump pump blue lid issue. It's odd, and the word bizarre was used, and I think that's kind of right. It's odd, but it's not sensational in the sense of, using another classic case, possession of cocaine when the charge is theft, and people don't like cocaine users and so forth. And then we understand, I mean, then immediately the case law lights up and everybody understands the problem. But here, the circumstances of flight, I mean, are truly, strike me again as kind of odd, but are they really kind of prejudicially sensational? I mean, you scratch your head, what's this guy doing? Does he have a mental health problem? I mean, I don't know. But is it really the kind of sensational act that requires suppression under a 403 analysis, for example?
Your Honor, it does. The only additional information that we get from Officer Moody's testimony about where they found him and how they found him is that they found him. And that's not relevant. The jury knows that. He's in the courtroom. He's facing this charge. It doesn't offer anything to the forgery. Almost all of this case is odd. And this particular evidence doesn't give anything to the underlying charge. And so it's sensational in the sense that it's very unique. And this particular chase and through a residential neighborhood and subsequent discovery, it doesn't give anything to the forgery. And that's why it's prejudicial and should be excluded. Nothing further. Thank you.
Thank you as well. The case of State versus Wilson is submitted, and we'll now hear the arguments in U.S. Bank.